Hello, and welcome to 3600 Seconds, where we bring you the week's top news. Today, we are here to discuss the upcoming Supreme Court case regarding Bertha Hunter, the woman from North Dakota who was denied the right to have an abortion. Under North Dakota's new restrictive law, House Bill 1305, women are not allowed to get abortions due to genetic defects known in the fetus, and she is now challenging the law in court. Ms. Hunter insists that the law is infringing on her autonomy over the pregnancy, and her lawyer, Mr. Lawson, argues that the Supreme Court decision on Roe v. Wade backs this up. The case moved through the state courts, as this was a matter of previous Supreme Court decisions. Initially, she planned to keep the baby, but during her pregnancy, she lost her job and had trouble finding a new one. She then decided to seek an abortion, saying it was because she felt she could no longer afford to raise a child, but doctors refused, saying she only wanted it because the fetus had Down syndrome and would therefore be more difficult to raise. James Lawson is seeking a Supreme Court decision to settle the matter and clearly establish pregnant women's rights in this regard, and he and Ms. Hunter are here to discuss their views and parts in this case. Dr. Ken Bradley, one of the medical practitioners who refused to perform the abortion Ms. Hunter requested, is also here to explain his actions and why he believes he acted correctly. But first, some words with Ms. Hunter. Mrs. Hunter, how are you feeling about tomorrow's court case?
Well, I'm feeling very confident about the case. When I found out that I was pregnant, I was ecstatic. I was thrilled. I'd always wanted a baby, and it was a blessing that I was finally going to have a child of my own. When Dr. Bradley diagnosed my child with Down syndrome, of course I was shocked. But I did not want my baby any less. I don't see how any soul could ever want to abort a child because of its disabilities. I already loved my baby, and I was going to go through the birth no matter what. And I was going to fight for my child and work together, and I was completely mentally prepared to give birth to a child with a mental disability.
And what made you change your mind about having this baby?
Well, when I was notified that the hair salon that I worked at was going to close due to the recession, I was distraught. My whole world turned upside down, and I've been searching nonstop for another job with no luck because of the tough economic times that we're in right now. And since I was already living on the bare minimum and could barely support myself, I began to reconsider whether or not I should have my child. I genuinely did not think I could afford to have my baby in the economic state I was in. When I talked to the doctors about this, they refused and told me about House Bill 1305 in North Dakota. I was completely unaware that a law exists that prohibits having abortions if it is because the fetus has a genetic disorder. This is in no way, shape, or form my reason for wanting an abortion.
And adoption was not an option?
When Dr. Bradley suggested I put my child up for adoption, I could not bear the thought. The idea of having my child in this world and not knowing he or she is painful. My friends have put kids up for adoption and I've watched them grieve. I'm extremely against the system and would never want to subject my child to that type of treatment. After I'd been pregnant for 20 weeks and the doctor still refused my request for an abortion, I decided to sue.
So, Mr. Lawson, what do you think about this case?
This is a clear-cut case of 14th Amendment violation. According to Roe v. Wade, a woman's right to have an abortion is protected until viability. Ms. Hunter initially sought an abortion after 16 weeks, when the fetus was not yet viable. So her right to have an abortion should have been protected.
So you think Mrs. Hunter was wronged in this case?
Yes. According to Roe v. Wade, a woman's right to have an abortion falls under her right to privacy under the 14th Amendment. The fact that the law prevented her from getting an abortion shows that it violated this right to privacy. It called for doctors to judge women's reasons for having an abortion based if they thought the abortion was because of some genetic defect. First of all, it doesn't make sense for doctors to judge this sort of thing. And anyway, a woman's reasons for having an abortion fall under that right to privacy. They're not the doctor's business.
So you said doesn't make sense for the doctors to judge women's reasons for having an abortion. Can you elaborate on that?
There's no way to judge to enforce the restriction. All like this only leads to women, like my client, being kept from exercising their rights based on the whims of a doctor. Ms. Hunter insisted that she sought an abortion specifically because of her inability to support a child. According to her, the genetic defect wasn't a factor at all, yet the doctors jumped to conclusions and insisted it was a factor anyway. Because of this conclusion jumping, because of this law, my client was denied a right guaranteed to her.
So you think the Supreme Court will vote in favor of your client?
Absolutely. Even though no one could prove that Miss Hunter was violating any law, she was still prevented from getting an abortion because of this law. The Supreme Court itself ruled that the abortions before viability are part of a woman's right to privacy. So of course the Supreme Court will rule once again that protecting that right is necessary and that this law, violating that right, is unconstitutional.
Dr. Bradley, how do you feel about this upcoming court case?
Well, I'm very interested to see how the Supreme Court's going to rule on this one. As you know, the mother, Miss Hunter, was under my care during her pregnancy, and she made it very clear that her intentions were to carry this pregnancy to term. She seemed pretty excited about it. A few weeks into her pregnancy, we performed standard genetic tests on the child to determine whether it was likely to be born with any cognitive or genetic disabilities. When the test results arrived, we did determine that the child was likely to be born with trisomy 21, also known as Down syndrome. When Ms. Hunter arrived at the hospital for her next prenatal checkup, she indicated that she wished to terminate the pregnancy immediately. When I inquired about Ms. Hunter's reason for seeking an abortion, she indicated that she felt she would no longer be able to adequately care for the child. I informed Ms. Hunter of a number of other options she had, such as a number of adoption agencies that specialize in children with cognitive disabilities. But Ms. Hunter was very, very sure about her decision and was certain that termination of the pregnancy was her only option. Unfortunately for Ms. Hunter, there is a North Dakota law that prohibits us from performing abortions on the grounds that the child has Down syndrome or any other genetic abnormalities. So my colleagues and I were unable to perform this abortion at our hospital.
How can you be certain that Miss Hunter's motives were because of the trisomy 21? How do you know that she just could not afford to carry the baby any longer?
Well, of course there's no way to be absolutely sure of the mother's reason for seeking abortion, but there are a number of factors that we look for when expecting mothers come in seeking terminations of their pregnancy at our hospital. One thing that certainly was peculiar was Ms. Hunter's timing in seeking this abortion. Curiously enough, she changed her mind about carrying the pregnancy to term almost immediately after learning that the child was likely to be born with Down syndrome. Another indicator for us that this pregnancy was being terminated because the fetus showed signs of Down syndrome was some of Ms. Hunter's answers to our prompts about adoption. She seemed extremely dismissive of the idea and didn't even try to hide that it was because she felt the child was likely to not be adopted because it had Down syndrome.
And lastly, what are your personal opinions about this case? If not for the North Dakota state law, would you carry the abortion?
Well, I never want to perform an abortion. There's usually a better alternative such as adoption. The obvious exception to this case is when the pregnancy threatens the life of the mother, but in Ms. Hunter's case, I certainly do not feel that Ms. Hunter should have sought this abortion because these genetic tests are not 100% conclusive. There was a good chance that this child could have been born completely free of any genetic abnormalities, and this pregnancy would have been terminated for no good reason.
Thanks. As you can see, there are very distinct arguments in this case. Bertha Hunter's trials have traveled through the state court slowly but surely, and now have finally reached the Supreme Court. Ms. Hunter's 14th Amendment rights are in question, causing this issue to reach the highest level of judiciary branch. The contradicting state laws and already determined court cases have led to a deep rift between the Hunter family and the doctors at North Dakota State Hospital. This case could lead to some progressive reforms if Ms. Hunter prevails, but could also further restrict women opting for abortions in the near future. Thank you for tuning in this week for 3600 Seconds. Good night.